Okay, first of all, I would like to thank my rector and general director and the colleagues of a scientific and organizing committee. Without them, this seminars could be possible. And I have to thank our guest who accepted to be here today. Okay, sorry. No, era per non fare sentire, adesso si sente, vabbè. As well as our participant at the call. We listen it today, tomorrow. And many thanks our administrative staff, because Roberta, thank you Roberta, thank you Maria Teresa, Laura, Alessio, because without them, who supported me, us in preparation and realization on this seminar. So, when I planned my German chair, on sustainability, ESG, and due diligence, I imagine to study the growing importance of global value chain and the protection workers overall in developing countries. And of course, I imagine to study the directive about due diligence and sustainability. But we know with the Omnibus One Package Directive, the CSRD directive is changed and now it's focused only on big company, 1,000 employees and 450 million euros of turnover. So entry in force is postponed, and we are waiting to new simplified ESRs. And also the due diligence directive is now applicable only in very large companies, 5,000 employees, 1.5 billion euros turnover, and it's postponed to 2029, July 2029, 3 years. We are waiting for 3 years. So, what remains of our project? In this seminar, I think about this, and we would like to try to examine the due diligence beyond the European directive. What is due diligence without the directive before and now? How the due diligence was implemented in non-European countries? What happened in European countries where national law about due diligence existed already? How the due diligence changed after both the directive in Europe and abroad? And how we could using other legal instruments that pursue similar objectives indirectly, as a legislation against labor exploitation or forced labor, occupational health, safety in procurement and chain, form of accountability in general. So we launched a call for paper. I'm very happy because 25 research and answered. Tomorrow we listen their report, and some best paper will be awarded. And we have also a scholarship of 400 euros for the best paper from developing countries too. This is the first of 6 workshops, 3 in Italy, 3 abroad, we planned for in the next 3 years. I don't know if all the goals of our chair will be achieved, but I'm already sure about one of them, the creation of an international network of experts in social sustainability, because we are here. So, many thanks to everyone to be here, and now I give the floor to my friend Aurora Cavallo is our coordinator of a Mercatorum PhD program on ESG and sustainability. Aurora, the floor is yours.
Thank you so much, Professor Moscella, and good afternoon to everyone. So let me say that in a way, these issues are strictly related to our, strictly embedded to our institutional DNA. As Universitas Mercatorum, we are founded by a system of Italian Chamber of Commerce. And in this sense, the way to depict the role of human rights, the role of the issues related with job, with the rights of job, with sustainability, play a primary role in terms of how to translate the reporting in a substantive action. And in this sense, also try to identify a way to recognize sustainability and ethics in our long-term value and corporate accountability. And so I'm confident that the today insights of our keynote speaker, international, but as well as national experience, as well as international practices, will provide a significant contribution to our understanding of this complex legal landscape. So let's start with our guest, Professor Bas Rombus from Netherlands. So his contribution is related with the issue of Dutch approach to the diligence and responsible business conduct in international and European perspective. Professor Rombos is Associate Professor of International Labor Law and Head of the Department of Private Business and Labor Law of Tilburg University. His research is focused on the crossroad of labor standards, human rights law, and sustainability. And so, Professor Rombos, the floor is yours.
Great. Thank you so much, dear Chair, dear Marco. That is a great introduction. It's always great to be in the Eternal City. And let's see if I can also present you with some slides. Yeah. Yeah. Oh, okay. Perfect. Should be on the... it's working now. Okay, great. It works. Okay, great. So it's a great pleasure to be here. Let's get started right away. What I would like to do today, and Marco has suggested to me that I have 20 minutes, no more, so I'll keep within that time frame, is to discuss the Dutch approach to due diligence and more broadly to international responsible business conduct, or IRBC. And the main goal would be to find out to what extent these Dutch initiatives may help us to better understand which different tools, which different instruments we could use to promote labor rights and broader sustainability requirements within global value chains. So what kind of different ingredients, what kind of different elements do we need for a smart mix of regulatory measures? So first, I will discuss the international framework for responsible business conduct and explain why it's so important to recognize that the UN Guiding Principles, OECD guidelines, but also the ILO M&E Declaration remain the normative foundation of basically all contemporary instruments, also the European ones. Secondly, I will examine very briefly 3 sort of generations of Dutch due diligence legislation. And thirdly, I want to discuss one of the most innovative aspects of the Dutch approach, which are the sectoral IRBC agreements. And finally, I will offer just a few reflections on what the Dutch experience could teach us at a time in which Europe is sort of rethinking its sustainability agenda. So many speakers after me tomorrow, today will discuss the specific European instruments, all the technicalities, all the relevant developments there. So what I wanted to do is take a little bit more time during this first presentation to zoom out and have a look at the international framework and then at the Dutch instruments. I think the international framework is particularly important because it is the foundation of all these other instruments that we know, also for the European regulatory initiatives. As for the Dutch story, part of it is happy, but part of it is also quite sad, but I will come back to that later. Anyway, I think it will still offer some interesting perspectives on the future of due diligence and corporate sustainability. All right, let's start with what we're trying to protect. So if we look at the specific labor rights that are relevant in light of the actions of transnational corporations, we see that all IRBC sustainability instruments, they always include the fundamental labor standards. They always include references to broader human rights law and also to broader ILO standards. This is important, and I know this is familiar information for you guys, but I wanted to repeat it anyway. So we have 140 million kids in child labor, almost 54 million kids in hazardous work. We have about 50 million people trapped in modern slavery, 28 million people in forced labor. Freedom of association is under enormous pressure in a world in which democracies are now on the back foot. Millions of people die each year by preventable illness and accidents at work. Discrimination is a very widespread and a very structural problem everywhere, also in high-income countries, which is exacerbated by rise of populist movements, xenophobia, and nationalism. Income inequality is rising with just a very tiny group of people owning more than the bottom half of the world's population. So there's a lot of work to be done, right? The overarching framework for sustainability is the UN 2030 Agenda for Sustainable Development that stresses time and again the very pivotal role that the private sector has to play. Is that better? Okay. That the private sector, can you all hear me? Okay, great. Yeah, so the important role that the private sector needs to play in protecting the social, the economic, and the environmental elements of sustainable development. So on the international level, we basically have three non-binding frameworks. So we have the UNGPs, UN Guiding Principles, the OECD Guidelines for Multinational Enterprises, and we should not forget the ILO M&E Declaration. These are, and I also think they should be, the sort of the basis, the vantage point for the vast majority of other IRBC instruments. So we have binding legislation now. We have at regional and at the national level. We have purely private initiatives, supplier codes, codes of conduct, public-private partnership, global framework agreements, etc., etc. Most of them, and basically all of them, are based on this international voluntary framework. And this also goes for the European and the Dutch, sorry, I'm too fast, and the Dutch initiatives. So I'm not going to give you a full overview of these three instruments. You know what they are, you know how they work, but I wanted to single out some of the most important elements. And also maybe recent forms of fine-tuning that give us a better idea about how these instruments do interact. Because they have been growing towards each other, finding ways to integrate key innovative functions and ways to complement each other. And this is also explicitly recognized by the secretariats of the ILO, the OECD, and the Office of the High Commissioner for Human Rights of the UN. So first of all, we have the UNGPs, which are basically a procedural instrument. Under Pillar 2, corporations have the responsibility to respect human rights, and this means that they have to conduct human rights due diligence, right? Which is basically a proactive process to identify real and potential human rights risks and address those in a way that is appropriate depending on whether the company causes, contributes, or is directly linked to the risk. So human rights due diligence is so important since it doesn't only require companies to be transparent about something or to report about something, but it is an instruction to actually do something, right? That's the big difference. Yeah, and as you know, this system of human rights due diligence has been integrated into the OECD guidelines and also in the ILO M&E declaration. Very importantly, the UNGPs, they say we cover all human rights, not a selection, not just a few rights, all human rights. They do explicitly mention the ILO's fundamental principles and rights at work as being the absolute minimum that needs to be protected. Another important element of the UNGPs is that in order to promote respect for human rights, there's no single silver bullet solution. There has to be what Ruggie has called a smart mix. So it's a combination of voluntary, binding, international, European, regional, public, private regulatory tools. We'll also come back to this idea later on when examining the Dutch approach. OECD guidelines then, they have been adjusted many times, have been adopted in 1976 already, and they now also incorporate this very broad idea of risk-based due diligence. They do not only cover human rights or labor rights, but also environmental protection, consumer interests, corruption, and a lot of other areas. So we see that the scope of due diligence, which was devised as a human rights tool, is expanded to now also include, for instance, environmental protection, right? Nowadays, people often speak of human rights and environmental due diligence. So the OECD guidelines are the broadest international instruments, and they refer to the ILO declaration and also include all the fundamental labor rights. Then my favorite organization, the ILO. As you can imagine, the ILO M&E declaration is very much focused on the labor side of corporate responsibilities. So just like the OECD guidelines, it is an instrument that was adopted in the 70s already, so a long time ago, and has been amended many times over the years, and now also includes due diligence. It is a tripartite instrument that focuses on social dialogue and addresses corporations, governments, and employers and workers' organizations. All right, so this is sort of the foundation of due diligence legislation and regulation. Let's have a look at what's been done in the Netherlands. So we'll start with the legislative track. And basically there are three steps. It all started with the Child Labor Duty of Care Act in 2019. And at that time, it attracted considerable international attention because it was among one of the first national laws to introduce mandatory due diligence obligation. So the act required companies selling goods or services in the Netherlands to investigate whether child labor occurred in their supply chains and to take appropriate action if those risks were identified. And child labor was, of course, defined through reference to the ILO instruments, so Convention 138, the Minimum Age Convention, and Convention 182, the Worst Forms of Child Labor Convention. And it also relied heavily on the OECD guidelines. It also included enforcement mechanisms, such as administrative sanctions. So it all sounded very nice, and for a while, the Netherlands was sort of the front runner. But here's the catch. Although the law was formally adopted by Parliament, it never entered into force. It was never implemented. So, yeah, the reason for this was that parallel to this development, there was a growing recognition that we need broader due diligence legislation. So laws that are not focused on a single issue, but in the spirit of the UN guiding principles cover all human rights, or even more than that. So this led to a second legislative initiative, the Responsible and Sustainable International Business Conduct Act in 2021. So this was a private member's bill, so a legislative proposal that was initiated by Parliament, and it represented a significant shift towards more all-encompassing due diligence legislation. So instead of focusing on a single issue, child labor, it sought to establish mandatory due diligence that covered all internationally recognized human rights. And the proposal clearly followed the structure of the UNGPs and the OECD guidelines. And it explicitly referred to risks associated with child labor, forced labor, discrimination, unsafe working conditions, exploitation, slavery, and restrictions on freedom of association. So in short, all the fundamental labor standards of the ILO, the fundamental principles and rights at work. Okay, so the reason, and this is, I think, interesting, the reason for developing this proposal was mainly because the drafters thought that Europe was being way too slow. So it was, its objective was also to accelerate, to put pressure on the European developments, to make sure that Europe would be adopting a law as well, because the position of Dutch lawmakers and policymakers has always been that in order for a real level playing field with respect to corporate sustainability, you need a European law and not different types of national legislation. So you could say that it worked because before the proposal could be adopted, negotiations concerning the S.E.E.D were concluded, and as a result thereof, the legislative process was discontinued. So again, not implemented. Yeah, so the third initiative emerged following the adoption of the S.E.E.D. The Dutch government began preparing for the International Responsible Business Conduct Act in 2024 in order to implement the directive into national law. Well, this is, of course, a logical consequence. So for the first time, there appeared to be a realistic prospect of integrating mandatory due diligence obligations into Dutch law through a European framework. However, as we all know, and as we will be discussing later on today and tomorrow, the European developments have altered the trajectory, and the Omnibus package and the Stop the Clock initiative reopened debates about scope, timing, implementation of sustainability legislation. So the Dutch implementation process slowed down again significantly. So at first sight, this legislative history may seem a little bit disappointing. So none of these initiatives have resulted in a fully operational due diligence law. But I think that the broader trend is important, the different steps that were taken. So these three generations, they sort of reveal a movement from a narrow focus on child labor towards comprehensive human rights due diligence, and ultimately towards integration within a European legal framework. So mandatory measures are, of course, necessary, but it's not enough. It's just one element of the smart mix that is required under the UNGPs. And Dutch policymakers, especially those within the Social Economic Council, that's an important advisory body to the Dutch government, they emphasize that there's more that is needed. And this brings us to the second part of the Dutch approach, which is the sectoral agreements. So arguably, this is the most innovative aspect of the Dutch model. So these agreements emerged following recommendations by the Social and Economic Council in 2014. And the objective was pretty straightforward. So you have companies, trade unions, NGOs, and governments, and they should collaborate within specific designated high-risk sectors to address sustainability challenges. And in total, 11 of these agreements were negotiated, and they covered different sectors: garments, textiles, banking, insurance, forestry, food products, floriculture, pension funds, gold, natural stone, and renewable energy. And what makes these agreements interesting is both their hybrid and their collaborative nature. So participation is voluntary, so it's a voluntary instrument. However, once companies become parties to the agreement, they accept concrete commitments. So it's also partly a binding instruments. All these agreements incorporate OECD due diligence requirements, and they all refer to the UNGPs, and they all also refer to the ILO fundamental principles and rights at work. So what do you have to do if you join such a covenant? You commit to carrying out human rights and environmental due diligence. So these are the 6 steps that we know very well. You have to integrate due diligence into your policy, identify risks, take action, monitor what you're doing, report publicly on the progress, and finally, but very importantly, provide for or cooperate in forms of remediation for the victims, right? So I think that's the most important step. A key feature is the collaborative approach. So instead of saying to a company, you have to do something, the approach is very differently. You put all these different stakeholders in different places to negotiate together, and they share information, they try to develop common tools, they collaborate together to try to solve complex supply chain issues that maybe companies only by themselves cannot solve. So we are all, or I think most of us are labor lawyers, or at least lots of us are labor lawyers. So we know that a sectoral model offers distinct advantages. Different sectors face different risks. Mining presents different challenges from banking or agriculture or manufacturing. And the idea was that a sector-specific approach would allow for more tailored solutions. So, for example, the Gold Agreement placed strong emphasis on preventing child labor and forced labor. And the Banking Agreement, for instance, focused much more on freedom of association and collective bargaining. In the context of these agreements, it was not only a commitment to do due diligence, but also very concrete projects have been carried out. For instance, about artisanal mining, artisanal copper mining in Peru. There have been projects to combat child labor, forced labor in sandstone quarries in India, and quite a few more. Okay, so the agreements functioned as sort of a platform for cooperation, learning, capacity building. According to official evaluations, the agreements generated basically 3 important benefits. So first of all, they increased awareness and knowledge regarding responsible business conduct. Secondly, they strengthened leverage within global value chains, the idea that you're stronger together, right? And thirdly, they provided valuable practical experience concerning due diligence implementation. However, I told you it's partly a happy story, it's also partly a sad story, because the official evaluations also identified very significant limitations. Most importantly, I think participation remained very limited. Only about 1.6% of the companies operating within those targeted sectors joined the agreement. So this is one of the major obstacles, as many of you know very well, to the voluntary track. So the leaders are doing the best they can, but the laggards, those companies that you really want to engage, they remain on the sidelines. So since the introduction of the first agreement in 2016, the Dutch government and the Social Economic Council have begun moving towards a new cross-sector IRBC model, which builds on lessons learned from the original agreements, while aligning much more closely with the European due diligence legislation that we're going to discuss later on today and tomorrow. So the aim of the new model is to provide companies with sort of shared due diligence support. So it will be more support-based model than a model in which the government is really a party to the agreements. Almost there. An important lesson from the sectoral agreements was that they may work, but only if they are supported by mandatory legislation. So this brings us back to the idea of the smart mix. And with that, I would like to make just a few very brief final remarks. I think if we want due diligence to work, we need to stay close to the spirit of the international framework of the UNGP's, OECD guidelines, and ILO M&E declaration. So they are a very broadly supported normative basis with also sort of a global mandate, global reach. I am a human rights lawyer by training. That means that I'm always a little bit cautious about single issue legislation. So I think that sometimes it might entail the risk of ignoring other highly important human rights or environmental issues. So I think a holistic view to due diligence is also very important. Human rights due diligence is great. Mandatory human rights due diligence is fantastic, but it's not enough, right? It's only one element of a combination of measures that we need for a more sustainable global economy. Well, then about the Dutch approach, you can look at it in two ways, I think. You could say it's a complete failure to adopt legislation, or you could take a little bit of a different view, and you can take the view that it shows some innovative and useful attempts to promote corporate sustainability and also to influence EU-wide developments. The sectoral agreements, with their sort of collaborative governance model, they encourage a wide variety of stakeholders, so businesses, governments, trade unions, employers' organizations, and broader civil society to work together, which is also, I think, an important point to improve human rights and environmental outcomes. So whichever way you look at it, these are all efforts in an ongoing process to search for a smart mix of regulatory tools that in the end all have the objective to improve the lives of those worst off on our planet. Thank you.
Thank you very much, Professor Rumbas. Yes,
Timing okay?
you're in time. And thank you so much for this insightful contribution on the Dutch experience, but also on the for your overview on European and international context. And so now let's depend this the role of human rights that you just mentioned with Professor Luca Nogler, which proposes a question, let me say, preventing human rights abuses in supply chains, duty of care or due diligence is the question that Professor Nogler give us. And so let's move to the supply chains. I would like just to introduce Professor Nogler, which is a full professor of labor law at the Faculty of Law of University of Trento, where he served also as dean from 2009 to 2012. And he has also a huge international experience teaching in Shanghai, Hamburg, Salamanca, Berlin, Bremen, and Madrid University. So I leave the floor to Professor Nogler. Thank you so much.
Dear Chair, Aurora, thank you for giving me the floor. And before starting my presentation, I would like to thank the University Mercatorum and, of course, Professor Marco Mocella for organizing this seminar and for inviting me this seminar on the legal concept of due diligence through supply chains. As you can see in my only basic PowerPoint presentation, your PowerPoint presentation was grateful. I will only speak for more or less 15 minutes, and just to make 4 observations. As it is right, I think, to leave as much time as possible for the subsequent general discussion. The first point concerns terminology. Then I shift to the problem of the concept of due diligence, first in the CSDDD or CS and 3D, as we say in general. And then on the concept in the United States general principles. And my last point is the national point of view, and the point of view of Italy in particular. So let's start with the first point while in Italian legal language one speaks of dovere or obbligo di diligenza, and in Spanish of diligencia debida, the German legislation, Lieferketten-Sorgfaltspflichtgesetz, we speak of Sorgfaltspflichten, and the French legislation that use the term devoir de vigilance. And you translate the Dutch statute as duty of care and not at duty or not of due diligence. I don't know. I don't know the Dutch language.
Zorgplicht. Duty of care.
Sorgpflicht, similar to the German language. So the Dutch system, Germany and France, have favored the terminology typical of continental civil law tradition. I think that it is so, where Italy, Spain have effectively transplanted in English the English term of due diligence by simply translating it into their national language. But more interesting is the second point, the second observation, which concerns the concept involved of these terms. Legal questions on concept, not on terminology. To this end, we must consider the wording of CS3D, and in particular Article 1.1 of the directive that provide a quote, this directive lays down rules on obligation for companies regarding actual and potential adverse human rights impacts and adverse environment impacts with respect to their one operation and so on, and on the operation of the partners in the supply chain. In my view, and indeed in the view of, I think, all commenters, there is no doubt that the liability arising from the obligation is not linked to the occurrence of harmful event affecting workers, who are the holders of the human rights protected by the CS and 3D. Rather, it is linked to the absence or ineffectiveness that is the adverse impact of the vigilance plane. Can we therefore say, and this is the dogmatic question of my presentation, in the light of the literal wording of the directive and using the French distinction between obligation de résultat and obligation de moyens, that this is an obligation of moyens. This crucial question must be answered in the affirmative if, only if, by this we mean that the classification of the obligation refers to the European Union legislature as due diligence in the English language, exclude the proposition that a company subject to the CS3D assumes an obligation not to cause harm to the worker of a supplier undertaking. A company subject to the CS3D does not undertake an obligation to guarantee that such a result will not occur. And in this means, it is, of course, an obligation de means. But classifying the due diligence obligation as an obligation de moyens does not exclude the possibility that an injured worker may prove before a court that the company subject to due diligence obligation is liable in negligence for the harm suffered simply because it failed to discuss with the due care the obligations laid down by the directives, once it has been, of course, transposed into the legal system of the member states of the European Union. For example, take Article 15 of the directive. If you can read in the PowerPoint presentation, it provides that, quote, member states should ensure that company carry out periodic assessment and ongoing obligation for their one operation and measure those of their business partners to assess the implementation and to monitor the adequacy and effectiveness of the identification, prevention, mitigation, bringing to end, and the minimization of the existence of adverse impacts. Such assessment should be based very appropriate on qualitative and quantitative indicators and be carried out without undue delay after significant change occurs, but at least every 12 months and whenever there are reasonable grounds to believe that new risk of the occurrence of those adverse impacts may arise. I consider in particular very important that Article 15 states that the appropriate measure that derives should be updated in accordance with the consideration of the relevant information from stakeholder. If at the time when the company ought to have monitor its vigilance plane, it were clear that a particular risk exists and the company failed to fulfill this obligation of prevention, mitigation, and so go. And if a worker subsequently suffers harm and he is able to demonstrate that the harm would not have occurred had the company aims its vigilance plane, then the company could be held liable and ordered the compensation for worker for the loss suffered. So the very crucial point, and this is, I think, my most important observation in my presentation, is that the term due diligence originated and became established in the context not of an employment contract, but of a sale contract, where it denotes an activity carried out by the partners in pursuit of its own economic interest. But in the field with which we are concerned in this conference, however, the concrete reality regulated by the directive is more and more complex. The company is subject, because why it is more complex? Because the company subject to the obligations established by the directive has no contractual relationship with the worker. And the second point, and this is a very important point, those who comply with due diligence or duty of care obligations, I think duty of care is more similar to employment law. It's more in the tradition of employment law, do so not only to safeguard economic interest, but also to protect non-economic interests. There are, in the sale contract, there are only economic interests. In the employment law, there are also non-economic interests. So the German, the Dutch, or the French translation is duty of care because it plays a role, this not economic interest, and the people's lives and well-being, and not merely their economic assets. Since what is at stake, the stakeholder, what is at stake is life itself in this topic. And it's constantly evolving reality. The obligation grouped under the label of due diligence in the directive cannot be reduced to an effort to comply with procedural requirements or a general commitment. Rather, in principle and in accordance with the United Nations guidelines principle, they also require the effective fulfillment of their relevant obligation and in a graduate and dynamic manner, the achievement of concrete results. So you have the obligation of result, not only of the obligation of moyens, as the French will say. Support for this view can be found, inter alia, in the fact that the effectiveness of the measure adopted by the attainment of the object must be reviewed on a regular basis. It's ongoing obligation, where the measure adopted prove inactive, specific consequences follow, affecting the future measure that must be taken. And so I agree with the German scholarship, which has argued that due diligence does not merely constitute a procedural obligation or an obligation of effort, but rather a graduated obligation of result, which where necessary must be fulfilled through the optimization of the measure adopted. So let's go to the United Nations guideline principle. In the debate emerged in the European Journal of International Law concerning the use of due diligence for the obligation, there was a critical position in contrary to the opinion of Raggi, that was the scholar that made the European Journal of International Law. And also Raggi says it is not only an obligation of moyens. In part, it is an obligation of result. And I think we must go back to this debate and to bring into the discussion of the directive the old question of the qualification of the obligation. So the last point is the national point of view, because as you know, the people, Italian people knows you, I don't, I don't know if you know this point. We have a public prosecutor's office in Milan, that is currently conducting a number of investigation concerning human rights violation occurring within supply chain located entirely in Italy. And this investigation have involved tens of thousands of workers whose employment relationships have subsequently been regularized. More specifically, the offense under investigation is that of a caporalato, we say in Italian. I think possible translation is unlawful labor exploitation through illegal labor intermediation. I don't know if Professor Pizzoferrato agree with this translation. A crucial point is that the company at the head of the supply chains is subject to this investigation because it is alleged to have negligently facilitated the commission of the crime. And so you have a very crucial point. If in the employment law, a client or principal have a duty of care toward workers in the supply chain. I think this is the question for the future. So if you will write a book about this question, it's not only a question for the public prosecutor in Milano, but also for the young Italian scholar. So thank you very much for the attention and for make allowance for my German pronunciation. Thank you very much. Thank you.
Thank you so much, Professor Nogler. From an ethical point of view, let me say, yeah. I'm not a lawyer, and anyway, it's really relevant to try to work on this issue and to try to identify a common platform of work on this. And so now let's move to the in a way strictly related to the Italian context with Alberto Pizzoferrato, which is full professor of labor law and at the University of Bologna. And Professor Pizzoferrato is also scientific director of the master's program in labor law. And the title of his speech is the due diligence approach of Italian multinationals. So I leave the floor to Professor Pizzoferrato. Thank you.
And thanks a lot to my close friend, Professor Marco Mocella, for inviting me to this very stimulating seminar. And I congratulate for this fantastic organization. Let me say just a couple of things before getting inside my speech, my presentation. I'd like only to make a couple of very brief remarks on the interesting considerations I've heard till now. The first one is that I totally agree with Marco when he said in a critical way that probably all the complaints that have been made to the slowing down of the effect of the directive were not justified. Because there have been, of course, setbacks, there have been involution in the normative measures, but then these piece of European legislation had played an important role as a booster, let me say, as a spotlight for the national legislation and for the national then experiences, either in a way of contractual experience, like in the Netherlands. Bas told us in a very meaningful way the situation. I would like to say that the situation in Italy, I will explain right now, is different, is very different from the Netherlands. We have regulatory measures. We have implemented the reporting sustainability directive, and also we have some other piece of legislation that is addressed to regulate these phenomena. So we didn't fail in the transposition, and at the same time we use a lot code of conducts, so voluntary track, but not made on a consensual basis, but on individual basis, I mean a unilateral basis of the company. Okay, so I would like to make a brief introduction and then go directly to the most, I think, useful and interesting matter I would like to share with you this afternoon, which is the Italian experience in the perspective of the Italian multinational enterprises. But before that, of course, we have to give a very brief story of the European legislation, because as we all know, the first step, Bas has already referred to us about the OECD guidelines, and also Luca did, and about the UN guiding principles. So I report to them. But the first step is the first step of the European framework is the Corporate Sustainability Reporting Directive, which, as we know, integrates sustainability reporting into corporate governance through the principle of double materiality. Companies are required to disclose not only how sustainability risks affect their financial performance, but also how their activities affect workers, local communities, human rights, and the environment. Sustainability reporting thus becomes an instrument of corporate accountability rather than a reputational exercise. So this is an important shift in comparison with the past. And then we have the second pillar, which is constituted by the as we know, Corporate Sustainability Due Diligence Directive 2024 number 1760, which introduces substantive duties requiring companies to identify, prevent, and mitigate adverse human rights and environmental impacts arising from their own operation, subsidiaries, and business relationships. Unfortunately, as I said, soon after its adoption, however, the directive encountered growing political resistance. European businesses argued that the cumulative effect of the CSR directive, the taxonomy regulation, and other ESG legislation imposed excessive compliance costs at a time of increasing international competition. These concerns, reinforced by the energy crisis and the recommendation contained in the Draghi report on European competitiveness, led the Commission to pursue a strategy of regulatory simplification and reduction, of course. The first step was the Stop the Clock Directive, and then the 2026 Directive number 470, adopted with the Omnibus Simplification Package, which further narrowed the scope of application. Marco has already told us this narrowed scope, which is this narrowed scope, and concentrated due diligence primarily on direct business relationship, unfortunately. So it is a way to reduce the scope of application of the duty of care that during all over the supply value chain, Luca told, Professor Nogler told us before. These reforms do not signal a retreat. However, I think that these reforms do not signal a retreat from sustainability objectives. Rather, they reflect a recalibration of European policy, seeking to reconcile effective protection of human rights and the environment with the competitiveness of European enterprises. In this context, the Italian legal system offers an especially interesting perspective, since many of the organizational mechanisms later incorporated into the S.E.E.D directive had already been developed under our domestic legislation. I refer, of course, to my written paper, but because we don't have time, otherwise I will exceed my time frame. But we have legislative decree number 231 of 2001 on corporate administrative liability, the legislative decree number 81/2008 that requires employers to organize health and safety management through continuous risk assessment and preventive planning. And then we have, as I mentioned before, the legislative decree number 125, so 125 of 2024, which implements in our legal system the CSR directive. Although the decree does not transpose the other directive, the successive directive of due diligence, it embeds sustainability into corporate governance by requiring companies to prepare sustainability statements in accordance with the European sustainability reporting standards and the principle of double materiality. So behind the disclosure, companies must describe their governance arrangement, risk management system, internal controls, and, where relevant, due diligence procedures concerning environmental, social, and human rights issue. So it is not something so complete like what it is prescribed and what it is binding for the due diligence directive, but in any case, there is an obligation of information which is very strict with the important sanction to guarantee the fulfillment of those obligations. But what about, so we have a composite, an articulated regulatory system. But then what is the experience of the Italian multinational enterprises? We have different models, all based, as I told you before, in a unilateral way, but there are different models depending on the sector of belonging of the company. So there is a first model characterizes large energy and infrastructure companies such as Enel, Eni, Snam, and Italgas, where due diligence has become an integral component of corporate governance. Rather than operating as a stand-alone compliance program, human rights and environmental protection are embedded within enterprise risk management, procurement procedures, internal auditing, and sustainability reporting. Enel, for instance, integrates human rights into procurement policies, stakeholder engagement, and supplier qualification procedures, supported by audits and corrective action plans. So something very similar of what it is prescribed by the due diligence directive. And also Eni has developed an even more articulated approach, combining country risk analysis, human rights impact assessment, consultation with local communities, and continuous monitoring of suppliers operating in high-risk environments. So not the business counterpart, but also on the business direct relationship, but also regarding the indirect business relationships. A second model is found in manufacturing industry, including Pirelli, Ferrari, Ferrero, and EssilorLuxottica, where the principal challenge lies in governing highly fragmented global supply chains. So we have this problem, this additional problem. Here, due diligence relies on supplier qualification system. So there are procedures to qualify, to identify the supplier and the fairness and the application of labor minimum standards by the supplier of the manufacturing industry. And this is guaranteed, granted also through contractual sustainability clauses, ESG audits, and codes of conduct requiring compliance with labor, environmental, and anti-corruption standards. So in the contractual experience, not only to the contractor, but also to the subcontractors, there are this model, this type of clauses which are imposed by the client with which are these manufacturing industry. And then so on. I don't have time to go in deep in this reasoning. So the crucial legal issue is no longer simply whether the undertaking knew of individual violations, but whether it had established effective organizational mechanism capable of preventing them. And this obligation of taking care of this effective organizational mechanism are enforceable because are unilateral, but when you adopt something in a unilateral way, then you are obliged to respect it. So these are enforceable before court. So the Italian experience, in my opinion, suggests that due diligence is progressively evolving from regulatory compliance into a broader model of sustainable corporate governance. And so even if there is, of course, a debate, there are criticism and so on. But I think that the most important lesson emerging from Italian multinational practice is that the future of due diligence will depend less on legislation than on market dynamics. The same Bas has told us before, it is something of business culture, not only it is a matter of legal obligations. I mean, illegal obligation, it's necessary, but not sufficient. Investors, financial institutions, multinational customers, and public procurement increasingly reward effective ESG governance, encouraging companies to extend sustainability requirements throughout their supply chains, irrespective of formal legal obligation or aside and in addition of formal legal obligation. For this reason, and this is my personal point of view, the omnibus reforms should not be interpreted as signaling a retreat from corporate sustainability. Rather, they mark the transition from a model driven primarily by legislation to one increasingly shaped by governance, contractual relationships, and market expectation. Italian multinational enterprises illustrate this transformation particularly well. Many had already integrated due diligence into their governance systems before it became mandatory under EU law, confirming that sustainable corporate governance ultimately depends less on new legal duties than on the capacity of organization to embed the prevention, accountability, and respect for fundamental rights within their, as I told you before, business culture, their business culture. Thank you for your attention.
Thank you so much, Professor Pizzoferrato, for introduce us to the transition of the Italian multinationals. And so now let's move to the French experience with Rafael Encinas de Munagori. I apologize for my pronunciation. Professor Encinas de Munagori is remotely connected with us. Good afternoon.
Could you hear me?
Yeah, clearly.
Okay, thank you.
Professor de Munagori is a full professor at Nantes University since 2002, and he is also member of the Research Center of Law and Social Change of this university. The speech of Professor Encinas de Munagori is related with the 10 years of French experience about penalties and civil liability since 2017 legislation of due diligence. So I leave you the floor. Thank you so much.
Thank you very much for this presentation. I'm very honored to talk to this panel, and many thanks to the organizer of the seminar, Marco Mucella, and my dear colleague also Martina Bassotti, who came in not recently. So I'm very sorry not to be with you in Roma today, and I'm afraid I would not be able to attend tomorrow the promising seminar, and with very interesting, I think, presentations. I know that for the audience, it's very disappointing to shift from real to virtual presentations, and it's kind of boring process, and I'm excusing myself for that also change, and I will try to best your interest alive. My talk will focus on the French experience about sanctions of infringements of the due diligence legislation, the French legislation, that two of my colleagues, Bas Rombouts and Luca Nogler, mentioned. And I will refer to this French legislation almost mostly. I think tomorrow and even today there's a lot of debate around the directives, but in France it's an interesting example of legislation prior to these directives, and I would like to talk about this experience. I'm going to share perhaps a PowerPoint. Let me try to share this one. I think it's here. Okay. Could you see the screen?
Yes, of course.
Okay, thank you. So let's start just with basic elements of this legislation, and after that I will move directly to the sanctions. So okay. So the French statute of due diligence, which is translated by devoir de vigilance, and you've got the official title under. It's always strange to talk sometimes in English with colleagues from countries from as Italy or other countries, European countries who have Roman, etymology, but we traduce it like the devoir de vigilance and not and not, for example, the duty of care. But duty of care, it's not easy to translate, even if I heard also the mention of my colleague Luca Noglu. So just a few points to present this legislation, I would say in a nutshell. First of all, it's a parliamentary proposition. The proposal is not a project coming from the government. And I think it's not a detail. It's very important in the story of this legislation, and also in the way the government enforce or not facilitate the application of the statute. So it came from, I mean, more the leftist part of the parliament at that time, and it was a miracle almost to have this law adopted. During the legislative process, it was long and subject to significant lobbying by multinationals. It's not, I think, something strange. And they fear that this new duty would harm the competitiveness of French business groups. There's always the same arguments now also at the European level. And some say, well, why not worldwide legislation? Why only European obligations? And so we have this kind of debate. But I think it's important to keep in mind that all the difficulties and the fight, it's about the enforcement, the application of this statute came from big companies. And so, well, I will come back at the end to ask a question. Where's the state between sometimes these groups, civil society, and multinational? Where is the general interest? It's part of the question. Well, so the act was finally passed in March 2017 and incorporated in the Commercial Code with 2 articles. And the center, the core of this obligation, it's a new obligation, a duty of diligence, but it's a formal one. A formal meaning that companies have to produce a plan, and this plan must include, and I try to translate perhaps the most important formulation of this obligation. The plan must include, well, it came from the international principle that were mentioned, for sure, with the idea to identify, to prevent, and also to mediate. But it was formulated very widely as reasonable to have reasonable vigilance measures to identify risks and prevent serious violations of human rights and fundamental freedoms, health and safety of individuals and environment, resulting from activities of the company and those of the companies it controls, which a debate about the scope of what kind of company in the supply chain has to be included. But my talk is not about the text itself or the scope. My talk it's on one point. It's what could happen and what happened during 10 years when the companies do not respect the text. And it's the question of sanctions, and I will just present 2 kind of sanctions, because in accordance with the objectives of to prevent and to repair, the legislator has devoted 2 correlative actions to the duty of vigilance. It's penalties and liability, and to also give it in the light of the words used in the directives. So I will present each one, and for each one a case, and after that give a small conclusion. So penalties, in the text, it's the first text, it said that any person with an interest in acting could act in that way, but who are those persons? Who are they? Well, it's any person, but especially citizens, workers, NGO, trade unions. It could be natural or legal persons, but in practice, it's clear that it's more groups like NGO or trade unions that are able to move and to organize. And they push the application of the law, and they also find a way to have these kind of penalties for certain companies. In the French procedure, there's also a 3-month formal notice, meaning that any action of this kind of individual or groups must be preceded by a 3-month formal notice. The company is summoned to establish the plan, and this formal 3 months is mandatory before going to the court. Before going to the court for penalties, but not mandatory before going to the court for liability. It has been precised by a decision of the Court of Paris in June 2024. And after that, what happened after the 3 months? There's a competent court jurisdiction who may order the company to comply with its obligation in this area, and if necessary, under penalty. And what is there? This penalty? It's under the kind of daily fine for delay in producing this document. And the company must draw up a vigilance plan and publish a report under the pressure of the court. One point I think interesting is that after a few undecided debates in France about which jurisdiction is competent, is it commercial necessarily, or it could be civil, it's now determined, fixed by a code, le Code de l'organisation judiciaire, saying that there's a specific tribunal, the Tribunal Judiciaire de Paris, who is competent, one only for the nation, for these questions. And I think to have a specialized jurisdiction for such a complex obligation, it's a good solution, or well, it's an efficient solution. Now, there was in the initial text a pecuniary penalty of 10 million maximum, who could be pronounced by the court, but the Constitutional Court the very beginning said that this statement discloses unconstitutional because it's contrary to the as a sanction as if it was, the analogy was with a criminal sanction, and it was not enough clear to have such a sanction and to have such a sanction. And so the text, it's a strange text because it was built thinking of this penalty, the pecuniary penalty, but now there's no penalty. But it's not because there's not this penalty that there's not obligation. And I am now just talking about the first case, the first application of this legislation. It was a question of the trade union of La Poste, and we can see here some workers because there were problems of undeclared work, harassment at work, not internationally, but in the country, because La Poste used some other companies, subcontractors, where there were this kind of problem. So what happened? It's that after the 3 months, is that La Poste, first of all, summoned the trade union, summoned La Poste in this 3 months to complete its plan and to talk and to try to identify the risk, to try to prevent the risk, and to have some procedure to take care of this problem. And there was nothing in the plan. And so the Tribunal Judiciaire de Paris, the 5 December of 2 years ago, condemned effectively La Poste, saying that he has to produce this document. He has to produce this document on due diligence. And it was a very interesting motivation, because due diligence here, it's not only compliance, it's wider than compliance. And the decision insists also on the collaboration with stakeholders to build and to establish this plan. So the word used was the concertation with trade unions and all stakeholders. There was an appeal, but the appeal upheld the judgment of first instance, and it was not only that the plan has to assess this risk, but also include a mechanism of alert to report these kind of problems. So it was an interesting and important decision, and it came only 8 years or 9 years. So you could say that pessimistic, that it's too late, there was only a few cases, but at least there was one real case 2 years ago. That's that's perhaps the case more significant of this first aspect, the first aspect, but there's not only in the first aspect, it's this aspect related with penalties, and this penalty, it does not necessarily have any damage. You could have only this obligation to produce this document and to go to the court to have this document elaborated. Now, it's true that the other aspect of liability, it's the more sensitive. In the French legislation, the choice has been made to use the common law. The common law, I mean the law in the civil code, the general proposition of civil liability, meaning classical liability. You need a fault, a damage, and a causal connection between them. So there were debates, but not other kind of objective liability for other partners. It's the classical. And here, where's the fault? The fault, it's just related with this obligation to publish or not, or to elaborate or not, this plan, this document. And so it's a very, audacious construction, saying that there's obligation to compensate when they are damaged, not for the real cause, you could say, but only the cause being that you don't have produced this document. So you have to compensate the loss that could have been avoided had the duties of diligence been fulfilled. So the fault, it's not establishing a good and adequate due diligence plan. Here, any person having an interest could act, but sure, there's a question of the burden of proof, the difficulty of evidence, and the evidence is, and this proof has to be demonstrated by the plaintiff. Here, the victims or trade unions or groups or NGOs were acting for them. Is there any case of this aspect in France? Yes, there's one, but there's only one, and it's quite a new one. It was this year, the 12th of March of 2026, with the well-known big company Yves Rocher. It's the first condemnation for liability of a company based in France for due diligence. And the problem here was about illegal, it was also a problem related with labor law and not with environmental problems. And it was the illegal dismissal of workers for trade union membership. These workers were working in Turkey, and these workers were working for companies related with Yves Rocher and being in this supply chain, technically more, yes, producing goods through contracts. But well, the important here, we were in the scope of the law, but the difficulty was that the plaintiff here, the workers themselves, but also the Turkish trade union, but French associations of human rights too, act on the basis of this legislation, and for the first time they obtain that the company was convicted, even if the damage was occurred in Turkey, and it's all the originality and all the debate about this kind of national legislation, who in some aspect have a extraterritorial effect. It depends, and also as important debate relating with other texts, European texts of international common law, if a private law, if this text could be considered as an exception, as a mandatory exception. So there's two cases talking about these two, to illustrate these two aspects of penalties or liability. We don't have 20 or 50 cases, but that's the beginning. It's the beginning, and I think it's difficult. I mean, to push a new text, and perhaps I don't know if the directive now one times translate is going to be a boost, or au contrary, something that could slow down the process. But persons who are optimistic say that they're at the very beginning, and it was very new, it was very audacious, and you got in front of you big companies who try to slow down this process, and you have to be positive. So just let me now conclude in a few words, and I don't like to speak too much on that. And my conclusion would be with this diagram. This diagram is not very complex diagram. It just say like a dynamic, which could be slow. You've got this national legislation. France is an example. There are others. Perhaps it's not better to have a national legislation. It would be better to have an international convention, but it's not the case. Perhaps we could have some directives more, efficient. well, it's logic, it's the first step, but what it's at the middle, I think it's more important. It's who are the actors? Who are the actors who are moving these texts? Well, there's the multinational. Sure, they try to push their own arguments and avoiding also this kind of legislation or this kind of interpretation and trying to push their own sometimes in-house code of conducts or regulations. But on the other side, you've got these groups, and I think thanks for them, there's evolutions, meaning trade unions, NGO, more probably than individuals, because it's too complex sometimes to launch this kind of conflicts. And at the end, well, it's not the more important, but there's some cases. There's also some negotiations between multinationals and these groups who try to have this transaction, avoiding to go to the court. And the cases at the moment in France, even if it was unexpected, well, we've got one clear case about penalties and one clear case about liability. And perhaps, I don't know if it's an example for others, but I think it's important for the debate we could have about this sanction and efficiency of this kind of legislation. Thank you for your attention.
Thank you so much. And so now we have maybe 15 minutes for comments or questions from the audience or from the keynote speaker. So please, maybe we can give the micro. Okay.
My question is for Professor Bass, and I would like to know if, given that supply chains are increasingly global, do you think national sector agreements remain viable, or should be similar? It would be nice to be similar initiatives be developed by EU level or maybe the international level.
Yes, thank you so much. A very good question. The idea behind the sectoral agreements in the Netherlands was already that they have sort of a global reach, but they targeted Dutch companies. So if Dutch companies did something in, let's say, India or in Brazil or in Russia, then they would already fall under that duty to conduct due diligence. What we see now is that out of the 11 original agreements, only 2 now are in force. And I spoke to a colleague of mine who works with the Socio-Economic Council, and she told me, well, it is also sort of their success that they're no longer in force. And what she meant by that is that now we do have European-wide legislation, but there are also initiatives, for instance, in Germany, that are tied to the Lieferkettengesetz, that are sort of similar to the Dutch IRBC agreements. But of course, Germany is way bigger, so they are much more successful. So as a front-runner experiment, I think having these agreements in the Netherlands is useful, but I think you're absolutely right that you need something broader to really cover all the global value chains that we have now.
My question is for Professor Pizzoferrato. Returning to the topic of simplification introduced with the approval of the omnibus package, we note that there has been a reduction of the definition and the role attributed to stakeholders. The question is, in your opinion, what are the main legal and practical consequences of this reduction? And if have you observed a different attitude and a greater spread among Italian multinationals to involving stakeholders in their voluntary application of due diligence obligation?
Thank you for your question. I don't think that this matter affects the application of this experience, this unilateral Italian experience. I mean, this experience grows irrespective to the existence of the European framework. I mean, the European framework is important. We had this law number 125 that is a milestone, is important. There are a lot of provisions, also strict provision, similar to the ones that our French colleagues told us for the French system. So I think that they play an important role to indicate a roadmap to follow. But then all these experience that we had in Italy are experiences born for reputational reasons, and then they evolved in a more incisive way, and so they become more strict, and they pose more additional obligation over the companies that adopt these measure, this reporting, this code of conducts, these contractual clauses, and so on. So my impression is that the normative questions like the one you have mentioned, so the reduction of the stakeholders necessary involved in the process, is not determinant in the evolution of our experience, because this experience is something new, ongoing, and not necessarily related to the evolution of the European regulatory system. Then, of course, if we have a strict provision, if you have a strict provision in the contents and broader in the scope of application, of course, the push is harder, is stronger. But then this doesn't mean that we can have also experience in this sense involving a larger number of stakeholders, even if there is not a legal European obligation. So I don't think that this kind of reflection on the concepts that we can find in the directive will modify, will influence so much the practical Italian experience.
There was also
thank you to all the speakers for the insightful presentations. I had two questions actually, but I suppose Professor Monogori isn't available. given it was online.
Yes, I can hear you.
Oh,
I can
hello.
hear you. Hello.
Yeah, I had a question. I mean, you outlined a couple of cases and said, you know, there hasn't been much development in cases that have, I suppose, been pleaded. Would you be able to offer any insights on perhaps any difficulties that you can identify in the French civil liability system? I know you kind of mentioned the burden of proof, but any other particular limitations that are holding back claims from victims?
Yes, I can elaborate a bit, but perhaps not as far as other colleagues could do. First of all, in the conception of the liability, the legislator or the group who really think about this link were not specialists of liability, of torts. And the problem is that they use this classical form of liability, but it's not totally adapted. I mean, the two classical aspects of a fault and a damage, and sometimes it's not difficult, but the relation of the causation, it's very tricky, because it's very indirect. That's saying that because the plan was not really well drafted, it didn't identify well, it didn't prevent well, it has not monitored enough what happened. So as a consequence of the damage, it's very difficult to prove. And sometimes it's what is interesting now. There's were other kind of torts who were more efficient, what we call responsabilité pour autrui. But if we stick with this civil liability, the classical one, it's not only to gather evidence; it's also to demonstrate this link between the actual damage, who could be national in the national territory or outside, and to demonstrate that is related with the defect of this plan, of this obligation to have a substantial and interesting plan. And the construction of the judges, actually, it's to elaborate really not only the plan as something formal, but to give nurture and structure about a substantial of what really has to be adopted in the plan efficiently. And that's very important, because it's what allows the parties after to have perhaps this demonstration of the causal connection. I hope I
Yes. So I have just one more question for Professor Rombaerts. You spoke kind of taking this holistic approach to human rights, and I suppose in that you amalgamate the environmental agenda. Perhaps you endorse the mixing, and of course that's what we're seeing now, in the European Directive. I just wanted to ask your thoughts about any concerns that you have, perhaps with the mix, and perhaps the environmental agenda taking precedence in kind of corporate due diligence efforts. Perhaps companies find it easier. I mean, it's certainly research out there to say they favor the environmental agenda or there's a separation of discourse because it's easier for corporations to grapple with the discussion. How do you feel about this, given that obviously we are a room of labor lawyers? Yeah, I just wondered what you thought.
Yes, good question. Thank you very much for that. First of all, it's always risky that companies take or sort of single out one specific topic that they feel comfortable with. So there's always a risk on that. I'm not sure if there is. I think if you view human rights and environmental due diligence as sort of a holistic package, then you will be forced to identify not all the risks, but the main and the major risk, and you will have to prioritize them as well. So what I also see is some developments within public international law that emphasize the very strong relationship between environmental rights or requirements and human rights. So there are a couple of interesting documents in this respect. I think there is an advisory opinion from the Inter-American Court of Human Rights, a recent one from last year, and also an advisory opinion from the International Court of Justice, I believe, on that. Those emphasize that human rights risks and environmental risks are very much interrelated. You cannot really separate them. If you have an oil spill, then local communities will be affected. If you have rising planetary temperatures, then this will mean that some farmlands will be affected and local communities there, or that certain diseases spread to regions that will now affect more people than, or different groups of people than they used to. So you cannot really separate them. And I think it's always risky. And that's also why I singled out the Child Labor Duty of Care Act to really focus on one specific risk, because it carries the risk of ignoring others. I hope that sort of answers part of your question.
Yeah, thank you.
So any other question or comments? Okay, so thank you so much to the keynote speaker of this afternoon. Thank you so much to Professor Mascella and to the scientific and organizing committee of this conference. I wish you an inspiring day for tomorrow, and enjoy your stay in Rome, and thank you so much.
Thank you, Aurora, too.